All right, everybody, thanks for coming. We're going to go ahead and get started. We want to keep you here all night. We've got a few extra seats because of the weather, so thanks for coming. What we always like to do is acknowledge all of our veterans. So if we could have all of our veterans please stand up and be recognized. All right, super. I'm AJ McDonald, the CEO and founder of McDonald Financial. For those of you that don't know, I think most of you do. But today we have Bryn from Gant Law Firm. And a couple announcements before we get started. I hand the mic over to her. Still getting used to this. The office is going to be closed on Thursday, June 19th for 19th Day. So still getting used to that. I think it's the third or fourth year that's doing that. Juneteenth Day. And of course, not a surprise, July 4th will be closed. That's a Friday this year. For those of you that have a birthday in July and August, we're going to have our July-August birthday party July 9th at BJ's Brew House in Fort Collins. Christy is in charge of all that. She'll be sending out an email soon. Those of you that want to come that don't have a birthday in July or August, my birthday is in August. So I'm inviting you. So if you'd like to come, we'd love to have you. Lastly, we have notebooks and pens on the table for you to take some notes. And with that, I'm going to hand the mic over to Bryn. Let's give her a big round of applause.
All right, thank you, AJ. I'm going to start out by asking if anybody cannot hear me very well. Is everyone okay? All right. Every once in a while when I'm in court, the court reporters will stop me and tell me I'm either talking too fast or too quietly. And I was just telling Abel this, that I actually wanted to do theater in college, and I went to the voice class, and I said, what can I do to help with my projection? And they had me do a couple things, and they said, I don't think we can help you. So I did not do that, but anyway, just raise your hand if at any time you can't hear me. All right, so I want to get started by introducing you to Bill Croft. So this is Bill Croft when he was 12 years old in about 1926, and he is wearing his three-piece suit, which he bought by himself before he went to the Ford dealer in a small town in Wyoming and bought a Model T Ford off the showroom floor. Bill had been homeless for a lot of his life. He grew up with a lot of struggles and trials, but he was very industrious. And so he had actually figured out how to take the gas flaring process and monetize that. And he was providing gasoline to some of the local gas stations. And so he had earned the money to buy this. Now, fast forward to 2008, at the age of 82, Bill was just as industrious as always, but he'd been diagnosed with dementia. And so his spirit and his mind were not cooperating really well. This was actually my husband's grandfather. And so I was newly married to my husband at the time, and we agreed to move in with Bill so that he did not have to go into a facility. And so that was my first sort of experience with dementia firsthand, and realizing that there were a lot of questions that came up. Are we allowed to make him take his medication? What if he leaves the house? Like, how do we help him get the right doctors? What happens with his belongings? If he forgets to pay his bills, who pays those for him? So that was my sort of the seed that started my personal interest in estate planning and elder law. And this is me with my kids who are much older than that now. I need a new picture in here. My daughter is 14 now, and my son is 9, but they're pretty much still just like that. We live in Greeley, and I'll tell you just a little bit background of my legal career. So I actually was a legal secretary before I went into law school, and I think that was really helpful for understanding just the logistics of the law firm. After law school, we had lived in Utah, and we wanted to be in Colorado, so we just took a leap of faith and just came out. I took the bar out here, and I actually got the job that I wanted, which was to be a deputy district attorney with Weld County. So I was there for just under 4 years, did a lot of criminal work. So I did everything from traffic all the way to, I ended up in the SVU, so I was doing child homicide and that kind of thing. And as part of that, I got to do some of the elder theft cases. And those were they're really sad for me because a lot of times they're very difficult to prove. So again, another thing that kind of steered me towards this area of law. So after the DA's office, I then went to private law, and I got some really good mentorship from a couple of law firms. But we were really lacking in a couple of areas in Greeley, and so I opened my own firm. So we now, we have 2 associate attorneys and me, and we do estate planning, elder law, probates, administration. Sometimes when the court needs somebody, they'll appoint us to handle somebody's probate for them. So we do all of that, and we also do family law, which I don't do as much of, but so that's us. So I'm going to talk to you today. I kind of decided to do this based on 3 areas. So myths about estate planning, mistakes that I've seen happen, and then just some of the basic must-knows about estate planning. And feel free to ask questions as we go along. Sometimes, I'll save time at the end for questions, but sometimes it's easier if it's on that topic already. So, okay, we're going to start out with myths. So the first thing I'm going to tell you is something that a lot of estate planning attorneys will not tell you, which is that not everyone actually needs estate planning. A lot of people do, but usually when you hear estate planning, you're thinking mostly of like a will or a trust as opposed to other documents, which we'll talk about. But you can think of estate planning like the legal documents that you need in order to make decisions when you can't. That could be during life or during death. And some people come in and they want to make a will, and they'll say to me, okay, I'm married and I have 1 adult child, and I want to give everything to my spouse, and then if they predecease me, everything to my child. And that's it. That's really all I want. And I will say, the law would do that anyway. We can make you a will if you want, but the law will actually do that anyway. So the other documents, again, we'll talk about those in a minute. But I've seen things like, I don't know if you've seen that advertisement that says, passing away without an estate plan is basically a donation to the government. And that's not true. There's actually default rules. So if you pass away, there's intestate laws. That's what they're called. It just means you died without a will. And they will basically do what most people already want, which is everything would usually go more or less to a spouse and then to your children. And then if those people did not survive you, that goes up to your parents, and then out to the siblings and down. And you can think of it kind of like out, down, up, okay? So you're not gonna just be left high and dry and your money just goes to Uncle Sam. Now, people that would want to consider more estate planning. So almost everybody, I would say, needs a power of attorney, which we'll talk about. If you have had more than 1 marriage, if you are common law married, if you are a life partner and you are not married and you are cohabitating, please talk to somebody. The most expensive case I've ever dealt with was a cohabitation where they thought, the one spouse thought that they left the house to the partner, and they put it in the wrong document and it was not valid. And so somebody who'd been together for 40 years suddenly did not have the house they thought that they were going to have, and also didn't have, labels on the plates, whose are whose. And so then a sister comes in and says, well, all of this is mine now. And it was a large fight over who got to actually live where and who got to take which property with them. If you have major assets in more than 1 state, probably you should do something, estate planning. If you have out of the country, if you own a business, if you want to give your belongings to anyone other than your spouse and then your children, and even if you have any specifics with that, like you have a specific heirloom you'd like to give somebody, or you want to give a different percentage than just 100% to your spouse. If you have any stepchildren, that's a really good time to do estate planning. So there are definitely a lot of people that need it. But for some people, the result is going to be the same whether you have a will or not. All right, myth number 2. This one you will hear from a lot of attorneys, and I wish that I did not have to say this, but the truth is trusts are more expensive, and so they are probably going to try to get you to do a trust, but you don't have to do a trust. I wish all of the attorneys were just very honest. But, the jokes are the jokes for a reason. Okay, so you'll often hear, though, the question, trust versus a will, what are the pros and cons of those? So trusts are more private. They, you can have them anonymous, but a lot of people, that is a benefit, but then a lot of people go and say Joe Smith's trust, and so then it's no longer super anonymous. They are more flexible. So if you've got, I'm a good example. My daughter has type 1 diabetes. So she's going to have a lot of medical expenses throughout her life. I don't want to give 50% to my daughter and 50% to my son. I want our funds to pay for her medical expenses and then 50% each. That's something that you really need a trust for. A will doesn't do that very well. So if you want flexibility, if you've got a child you don't really trust and you don't really want to give them a windfall, but you'd rather it used for specific things like their health, education, maintenance, and support, then you can use a trust to make sure that they don't just get a large chunk of money from you. So they are more flexible. The other thing, though, is they are more difficult to maintain. This is what I really try to drive home to people. So you can think of a trust like a business, whereas a will is a document. There is a document for a trust. It is a trust agreement, but it's not the whole trust. It has to be thought of like a business. So if you started a business and you bought a car for that business, but you bought it in your own name, that's not a business asset necessarily. You got to put it in there. You have to put it in that name. And so the same thing is true of the trust. If you buy things, you buy a new house, you make a trust and then 10 years later you move and you don't put that new house in your trust, now you have a trust and you have a non-trust asset that's going to go through probate. So if you're not good at keeping up with those things and keeping track of it, a trust can actually be worse because you may end up in doing trust administration and probate. Now, the last major difference. So who here has heard that a trust will keep you out of probate? Anyone heard that? Like, do a trust because you won't have to do probate. Probate, well, I'll just ask openly. What do you think probate is? Does anybody want to take a guess at, or maybe you've gone through it for a family member? No one wants to say it. Yeah, it's a process is what it is. When you hear people say, oh, it's a nightmare, stay out of probate, most of the time what they're talking about is a contested probate. A regular probate is kind of like a more intensive version of doing your taxes. Okay, it's obnoxious paperwork. There's a lot of legalese in it, which I wish we didn't have to use, but there's so much case law and precedent that we have to keep using these silly terms. And it's really just filing stuff with the court and making an inventory of assets and then divvying those out and paying debts. And not in that order. Paying debts and then divvying out the assets and then closing it. It's not that bad. It can be bad, but it's really not that bad. And Colorado has done a really good job of creating instructions for it and forms for it. They have, usually almost every jurisdiction has a probate registrar that's only for that. It's like a clerk. They can't give you legal advice, but they can answer questions. So if you're really worried, you don't want your loved ones having to go through probate, what you really mean is you don't want them fighting. And as long as they aren't fighting, a probate is almost as easy as a trust administration. Because I think the second most expensive case I've ever seen was a trust conflict, not a will conflict. So, trusts are not always better than wills. They are good for some things. All right, myth number 3 is about direct gifting, and we had talked about this earlier with, I think, Mary Ann here. So direct gifting is something you'll hear about. Has anybody ever heard, if you just do beneficiary designations or direct gifting, you won't have to go through probate? Has anybody ever heard something like that? Oh, well, maybe this isn't that helpful of a myth then, but a lot of people used to be told, oh, just put your child on your bank account and then put them on your house, and then you won't have to do anything, when you pass away, which is, it's an option, but it's sometimes not the best option. So when you pass away, your personal representative is what it's called in Colorado. You'll also hear it called executor. If you have a will, or a trustee, if you have a trust, is going to administer your assets. And if you have certain assets that have a beneficiary designation, those don't have to be administered. Life insurance is the easiest example. So if you have life insurance, you always have to put a beneficiary on there. When you pass away, the life insurance company learns about that, and they literally contact that person and just give them the funds directly. It doesn't have to go through probate. It doesn't go through a trust administration. You can do a similar thing with your bank accounts and your house. So it's true that if those pass directly, then you don't go to probate, but there's some issues with it. So for some people, they don't realize that those come off the top, so to speak. So if you have 2 children, you wanted to give them 50% each of your estate, and you had to put one on your life insurance, so you did, that one gets that amount and still gets 50% of your estate. It's not like that diminishes their 50%. Okay, so anything with a direct beneficiary designation comes off the top. The other thing is it can cause issues with skepticism in families. And so this isn't really a legal thing that you can fix, but anytime that one person is getting more than the other person, it's an opportunity for a fight, especially if you didn't say anything about it. So if there's a direct beneficiary designation, especially close to the end of your life, those cause fights pretty often. Another problem with them is they can actually disqualify you from Medicaid. So if you do a beneficiary designation on your home, for instance, and it'll say this right on the form, you can say, when I pass away, I want my home to go to my daughter or to my spouse. Well, that would be a joint tenancy deed, but either way. So if you put your daughter or your son on your home, then if you need Medicaid any time in the next 5 years, you're going to do a Medicaid application. When you do that, Medicaid is going to ask if you have given away anything of value within the last 5 years without getting paid for that. Any large gifts, and you have to provide that documentation. They will also search the county records, and so if they see your beneficiary designation for your child who you want to get your house, they're going to call that a gift without consideration, and they're going to penalize you dollar for dollar the value that you gave away, and you will be disqualified for Medicaid for those months. There's a slight exception to that for super hardship times, but I don't think I've ever seen Medicaid do that hardship exception. And so they will just penalize you, and you will not be able to have those funds for that time. So yes, it can keep you out of probate, but sometimes it does not help as much as we wish that it did. Any questions yet? Anyone?
Is probate associated with trusts and wills?
Only, no, it's only a process for wills. So that part is true. And then when people say a trust will keep you out of probate, that's true. It just doesn't stop the fighting necessarily. And what you usually are trying to avoid is the fights. So the probate process is, you can think of it like a 5 or 6 step process. If you have a will, and this is actually a myth we could add here, there is no reading of the will. Like we see, where the attorney calls people in and they sit around a big table and they tell everyone what they got. That doesn't actually happen, although I've toyed around with doing it anyway, just because people want it. So basically, your loved ones will find your will, and then they will bring that to the courthouse. Whoever you named as your executor or personal representative is kind of the manager of this process, this probate process. They will file opening paperwork, and they will have to choose a couple of things if they want to do it formally or informally, which is usually just if it's going to be a fight or not a fight. And then they will put a notice in the newspaper to tell all of your creditors that you've passed away, and your creditors will get 4 months to bring forth their claims. And then they wait for those 4 months. And meanwhile, usually they're making an inventory, which is something that would be really helpful to all of your heirs, is if you would keep an inventory yourself. They can start somewhere. So they'll go do an inventory of your assets. After those 4 months, they look to see if any claimants have come forward, any debtors saying that they're owed something. If so, they try to pay those debts. There's some specific rules about that. If not, then they just go to your will, or if you don't have a will, to the intestate laws, and they figure out who's supposed to get what, and then they distribute it. They can sell things if they need to and distribute cash, or if they can reach an agreement with heirs, sometimes an heir just wants to receive an actual item and they just take the value of that item as part of their inheritance. And then they file closing paperwork. So if it goes smoothly, that's the whole process. There's not a ton to it. It does not happen with a trust. Similarly, though, if you have a trust, when you pass away, your trustee will find the trust agreement, read all of the rules that you set out in your trust, and then they're the manager of that process, and they will follow the rules that you set out, which is also going to include making sure they have an up-to-date inventory of the trust assets, paying your debts. Usually a trust does not always protect you from debts, and then distributing your assets to whoever you said to put them to. So the only difference is you don't file the opening and closing paperwork in court. And actually in 2018, prior to 2018, you still had to file paperwork in court for a trust administration too. Now you don't have to, but it's usually advised to. So it's very similar process both ways. Good question.
Is it Colorado law that you must file a notice in the paper?
If there's been 1 year since the date of death, no. But if it has been sooner than that, you have to file a notice in the newspaper once per week for 3 weeks. And every newspaper is aware of that. They know kind of what it looks like. And so if you call them and just say, I need to place this type of notice, they'll get you to the right person and help you write it correctly. I guess that's probably one of the kind of trickier parts to it. But once you've done it or you've talked to the person at the newspaper, it's not too bad. Any other questions?
Are there any newspapers anymore?
Not a physical. I tried to get one because I was feeling nostalgic and I wanted one. And I signed up for it and they delivered it one time in 5 months. And so I had to cancel it. Anyway.
That announcement's pretty secret anyway.
Yep. No one's really reading it. So it's really just to check that box and make sure that creditors have had their chance if they wanted it.
I want to tell a story about a creditor.
Go ahead.
We published in the paper that my husband had passed, and I didn't know that he had this debt, and the person contacted me, and he wanted me to pay the debt and the attorney's fees. And I told him, if you had contacted me instead of an attorney, we could have taken care of it. So I am not going to pay the attorney fees. That's up to you.
Yeah, I think that's good. I mean, most of the time, attorney fees have to be borne by whoever got the attorney. There's some times where that would change, but yeah, hopefully nobody gets an out of the blue debt in the process, and in which case you may want a trust instead.
I have a question about transfer on death.
Yes. Yes, and that's the same as a beneficiary designation. So if you've heard of a transfer on death, that's the same type of vehicle where if you have a transfer on death document, that's going to go off the top outside of either trust administration or probate. So go ahead.
If I have a friend who wants to do this with her home, how does she do that? Where does she get the paperwork at?
I mean, I can tell you there is a form that you can get from the real estate, from the online at the real estate thing, or I can draft a deed. But I would tell her the same things about you're going to be disqualified from Medicaid, so be very careful with this. And just making sure you understand it goes off the top and it's going to go directly to that person. One other thing with the Medicaid, if you are going to go into a facility and living with a child would not make you go to the facility, they can stay with you in your home. That's another way that you can get around that penalty. There was a question. Mm-hmm.
I have a question. So, like, I'll use my own mother for an example. We sold her house and she did go into a facility. So upon death, her money just got divided.
Mm-hmm.
But what I wonder is, what about the debts that she might have? And once you divide it, who's responsible for that then?
So the debts are usually paid first, and that's why we give that deadline. And they're paid in a specific priority. So, for instance, taxes are a higher priority debt than any consumer debt would be.
Banks just cut a check right away. They didn't wait to see if there was.
Okay, so they have to file. If you open the probate to distribute the funds, although maybe there weren't enough funds, did you open a probate?
My sister did it all, but
Okay, so
still, when she passed, I was amazed how quick we all got a check. And then there were bills that came in.
yeah.
We all kind of went, we'll take our share of it.
That was probably correct. She may have given you the funds too early. Okay, so if you are the executor, personal representative, and you go out of order and you don't wait for the claims to come in and you start paying people money instead, the claimants are allowed to take those funds back from the people that got it. So that was probably why you guys did that.
It was the bank that issued the checks, by the way.
Oh,
I mean, they didn't.
it was the same bank that had that issued the money out that was owed the debt back. Someone wasn't talking to someone. Okay. One other, this is kind of a lingering myth that's been around, and it is that if you do an LLC, you can avoid taxes with that. And it's sort of true and sort of not. Has anybody heard this myth to get around estate taxes? Okay, so let's go over this one just briefly in case it comes up for you. We won't take too much time on it, but little background on taxes. So I like to think of taxes as the IRS taxes events as opposed to money. And one of the events they can tax is gifting. So if you give away things in your lifetime. And so when we hear about trying to avoid the estate tax, that's what we're talking about. It's separate from an income tax. Today, you are allowed to gift $13.99 million during your lifetime before that becomes a taxable event. So as a couple, it would be around $28 million. So if you haven't gifted $28 million, you're okay, or $13.99 million. However, that law is set to change at the end of this year, December 1st. I think it should go to January 1st of next year. It's probably $6.5 million to $7 million for your lifetime. If it sunsets, we'll see if Congress changes that. So if you're under that, then you don't need to worry about it. But back before that happened, 2018-ish, people were using LLCs to try to get around this gifting, because what they would do is they would put all their assets in their LLC, they would make it a family business, and then they would give these tiny little percentages to family members, and that tiny little percentage was a non-voting percentage, and so it wasn't really worth anything. So then you could get an appraiser to say, oh, that's 40% less the value of the assets. That's not really worth anything. So it's not really a gift, monetary gift anymore. That is technically still a thing, but the IRS has gone to court on that multiple times and they've won, where they've said, no, it's worth as much as the whole thing, but 2% of the whole thing. It's not less just because it's a non-voting share. So that's a myth, but if you hear it, LLC is probably not a great way to try to avoid estate plan or estate taxes. Estate planning is only for the elderly. I always tell this to people, anyone with minor children, I think is probably the number one person that should have an estate plan, because if you go on a trip and both of the parents die, there's usually a very large fight with who is going to take care of those kids. There are lots of loving family members on all of the sides who are grieving, not thinking straight, and it really, really harms family ties. So minor or disabled children, if you're going out of town and you have bills to pay, surprisingly, mortgage companies will not just accept money from anybody. So if you go out of the country and a flight gets delayed or something like that, and a mortgage payment comes due, and you don't have a power of attorney, you may not be able to make that payment. Health concerns, if you're going to go in for a surgery or anything like that, if you're under anesthesia and something goes wrong and your doctor needs somebody to answer, do you want option A or option B? You need a healthcare power of attorney so that you can choose the person that's going to make that decision for you. All right, last one. Everything will be easy if you get an estate plan, which is also not true. I wish that it was. But I have had to, so we, at our firm, we do estate planning and we also do administration and we also do litigation. And so it's kind of, in some ways, helpful for my clients because I can see, oh, that went wrong on that document. We're not going to write like that. We have to fix that issue when we're drafting. So I've seen some where I won't give you specifics, of course, but a kind of an example would be if someone were to say, I want the following people to be my executor in this order. And then they do bullet point 1, Sam, Joe, and Jenny. Bullet point 2 is empty. So now was it Sam first, and then Joe, and then Jenny, or was it all 3 of them because they're all on one line? And then, of course, if you don't have an Oxford comma, which may or may not have been an actual example, then you have one person and then maybe the other 2 together. So things like that can get really complicated if the estate plan is not drafted correctly, which is why I always get that question, can I just do a will online? Sometimes, yes. I've seen cases where that would have worked all right. Sometimes people will come to us and they'll say, well, I did a LegalZoom will. I just want you to look at it. And look, we have enough work at my firm. Like, we don't need to ask for more work. And so I will, if it's a good will, I'm going to tell you it's a good will. I've had some, though, where I have to say, well, you did the residual clause before this clause, and so now what you've basically said is all the leftovers go to these people, and the main stuff goes to these people, but you did it in the wrong order. That's going to cause confusion. Or the case that I talked about earlier where the partner wanted to give the home to the partner, and they put it in the wrong document. And it's real estate. You got to put real estate in the right thing. And so it was a non-valid document. It failed, and the home went to the sister. So it's not always easy just because you did it. You have to make sure that you do it correctly. Number one thing on this, and if anybody wants an example or a template, you can email us or call me and I'll send it to you. It's not a legal document, but once a year at least, quarterly if you can, maybe on your birthday so it's easy to remember, make yourself a personal property inventory if you don't already do this. It should have on it your real estate, it should have your vehicles, it should have your bank accounts, life insurance policies, retirement policies. Well, you probably already have all of that, but basically writing all of these things out. And then where do you keep your photos? Do you have a password on your computer? Don't keep the password digital, print it out and write it down somewhere. It's much less likely to get stolen if it's written down, or you can put a hint to it. But if your executor, your loved ones can find a document like that, it takes the worst part of probate or the worst part of trust administration and makes it easy. Because now they know, they don't have to go sifting through paperwork. Where did dad bank at? I don't even know where he banked. Trying to go through your mail and figure things out and wondering if they missed a large asset that they just didn't know about. So write it down once a year. It's kind of a process, and it's nothing that an estate planning attorney will help you with because it's not a legal document, but it's important.
Can I ask you a question? Tying into that, even though you just said that an attorney wouldn't help you with it. So have you seen the commercials for the Knox box?
Yeah, I think so.
Yeah, so it's basically hey, if I die, here's the box that, my brother could come in and see everything like what you're talking about, personal inventory.
Oh, okay.
And so I was thinking that it would be a good product for whoever I would choose for an estate attorney to offer something like it
Yeah.
in box form. All the file tabs were like, here's the vehicles we have, here's the 5 bank accounts that we have, here's the mortgage company.
Yes.
Do you offer anything like that?
We don't, and I will look that up. I think that's a great idea, as long as it's kept up to date. That's the only problem, is if it's not. If it's something that the company has to do and you don't know how to update it, I wouldn't want that to be a barrier, because the worst part is when there's questions. We're like, well, we know we don't have that car anymore. That's from 10 years ago. And then they have to kind of redo it anyway because they don't trust what they're seeing. But I love the idea. What is it called again?
Knox box.
Knox box.
KNOX.
Yeah, I'm going to look that up. I wish there was a registry. In Florida, when you do a will, you immediately give it to the court, and the court keeps it for you. And so everybody knows where to find it. There's never a question about, well, I think my brother got in there first and ripped it up. So, no. And actually, the attorney doesn't usually keep it either. They used to. But usually you take the original home with you, and you want to put it in a safe deposit box or a fireproof safe or something like that. Yep. Things I wish that I could... all these ideas that I had that I don't have time for, but I'm going to write them down. Any other questions on that? Okay, any other major myths you've heard about that yeah. Well, how would you know? I mean, might be a myth, but. Mm-hmm.
I know a person that has quite a bit of credit card debt, but he's not concerned about it because when he dies, they're just gonna, let it go off the wayside rather than having kids take care of it.
Mm-hmm. Probably not. It depends on the credit card company. So some of these credit card companies, they are watching newspapers. They're looking at those pretty constantly. And sometimes they'll even have somebody assigned to be checking for that or checking estate filings. And all they have to do is submit a claim form within those 4 months, and then that claim has to be paid before anything else. In fact, a creditor can open an estate for you. So if you pass away and your loved ones are just trying to stay hush-hush and they don't want to do anything, a creditor has standing and has a right to go into the court and file your probate for you if they want to get the funds back. Mm-hmm. And a trust is the same way. If they don't hear about the trust, which is a little more likely because you're not going to be publishing in a newspaper, but if they hear about the trust, most of the time you can't get around true, real creditors in a trust. Yeah, good question.
Is the state of Colorado prescriptive about the newspaper filing? For instance, shouldn't I tell my kids to file the notice of my death in the Trinidad Press?
No, yeah, they figured that one out. So yeah, it says it has to be in a newspaper of general circulation within the county that you passed away in. And then if there isn't one, then you have to go to the next most likely, like the largest one in your area. Yeah, that was smart though. Yes, go ahead.
Do you think it's a good idea in general to sit down with your kids or whoever, your relatives, and talk about your will and give them an idea of what to expect?
That's actually...
Better to surprise everybody.
Okay, so that's actually one of the things I was going to talk about in here. We're just going to go to it, but I'm not going to move the slides just in case I muddle up my slides. Yes and no. If you talk to them, you must always talk to them about any changes. That's the hardest part. Not must, but I really think you should. I'm telling you. If you've said, I'm going to give you XYZ, and then later on that person makes you upset and you change your mind, and it's uncomfortable to go tell them, I changed my mind. When you pass away and the other person gets XYZ, they are immediately going to be grieving, they're not thinking straight, and they're going to say, what did my sister just do to get that from dad? So if you're going to talk to them, keep talking to them about changes. And I think that's the better way to do it, if you can, rather than just not saying anything ever and then surprise, here's what's happening. Unless it's not too much of a surprise. If it's what everybody would expect, you've got 3 kids, they're all going to get a third, then it doesn't really matter too much. But if you're going to do something outside of the norm, then I think it's better to let people know so that they know that you made that decision when you had capacity. So most of the litigation that we see is people being surprised by what the outcome was, and then thinking that somebody was up to no good and that you were unduly influenced, which does happen. I've seen that a lot. I've seen somebody who was a boyfriend of an 85-year-old woman. He lived in Denver and was married, and she lived in Greeley and was giving him lots of gifts and money. So that does happen. And I've also seen a housekeeper is suddenly the beneficiary of all of a person's estate, and their 3 children have been written out in the last 2 weeks of their life. So that happens. So we need to make sure that the people they're aware that was not the reason you made your choice. One of the things we do in our firm, and if you're ever looking for an estate planning attorney, you can ask them this: do you do a sort of an examination of mental capacity before you sign a will? So when we sign wills, everybody gets the same questionnaire, no matter how you are in life. You're going to be asked your name, you're going to be asked your questions about your highest education level, you're going to be asked to spell the word world backwards, and a couple of other things like that come from the mini mental health or mini mental status exam that doctors give. And then we make sure nobody else is in the room. Like if a child drives you there, that child needs to step out for portions of it, because a lot of times people will sign documents with one sibling or one child in the room, and that does not go well on the stand later when that attorney gets called into court. So you can always ask, what do you do to make sure that you have notes on my ability to sign this and not be unduly persuaded by anyone? So that was a good question, which I answered really longly. So any other questions? Yeah.
I was just wondering, do you think it's a problem to list more than one person as an executor? Are there arguments for that?
There's pros and cons to it, and you're saying at the same time, right? Okay, because most people will say, I want this person, and if they can't, then this person. If they can't, this person. That's normal. You should always do that. So the question is it okay or is it bad to have two people serving together? Pros and cons. So if two people are serving together, there's division of labor. They can share that process, which is helpful. One of them can do this, one can do that. They won't feel left out sometimes. They can feel like they're doing something meaningful for their loved one. Where it can go wrong is the one main one is you want to say if they're allowed to make decisions separately. You don't want a bank, for instance. You're coming to get money from the bank to make checks out to people that are owed money. And they say, well, there's two of you. I'm not doing this unless you're both here, especially if one is out of state. So when you're drafting, a good drafting attorney is going to say these two people together, and either one can make these types of decisions separately, and any financial institution who is reviewing this has authority to take the word of one as the word of both or something like that, so that you don't get hung up on that. And then the other one is just to make sure that they don't have huge conflicts. If you think that they're going to have really big disagreements about how things should go, then it's probably best to just pick one or the other, because they might have to get the court involved to work out their argument, and that's expensive. So, yep, good question. Any others?
I guess I have one.
Mm-hmm.
We have 3 kids, and so we have one son that's the executor, but then we feel like the other kids are left out, or if that will bother them, and so we were unsure whether they should all 3 be executors, or just the one, or have succession, or...
Yeah, it's a good question, and it comes up a lot, and there's not a great answer. Sometimes what I've done is I've added a letter along with your estate planning documents to explain your thought process, and you can just say, like, I don't want anyone to feel left out. This is why I chose this person. You just don't want it to muddy the legal authority. You wouldn't want it to say, I don't want anyone to be left out, and now the other 2 children are like, well, mom said that, so now I get to be executor. The will is the will. The will says who's executor. A letter can go along with that. It's not a legal document. It's just an explanation of what you were thinking when you did that. That can help. Or yes, you can put them all together as long as they get along pretty well. I've seen that work quite well when we're helping people administer, multiple people doing the same, having that same authority, and as long as they get along well, it works okay. Mm-hmm. All right, so conflicting paperwork. I got a question earlier about doing an amendment to a trust or a codicil to a will, which is the same thing as an amendment, but in will speak. And the only thing that I watch for with that is if the paperwork looks really conflicting, that's an area where people start to raise their eyebrows. So if your heirs see, well, dad went to one attorney for 20 years and then got this codicil to his will with this other attorney, 2 months before he passed away, people are wondering why that's the case. So if you've got, you printed off a power of attorney online, you went to a standard attorney for a will, and then you drafted some of your own paperwork about your funeral requests, that's an area where people might start to fight. So you want to have uniform documents when you can. If you've got a family that gets along great, it probably won't be a problem, but sometimes we've seen people say, well, then why is this different, right? So you want all of your documents in your estate plan to look the same if possible. All right, so this was the one that you talked about, conflicting messages. You make promises during life, and then those aren't in the estate plan or they're not upheld. That's really tricky, especially because we have something in Colorado which is called the dead man statute, which is it's an additional rule for how we present evidence in court, which says that if your loved one told you anything verbally, or even sometimes in writing if it's not a legal document, and they're not here to talk about it, they've passed away, and it would benefit you, then you can't bring it up in court. Even if it would normally be an exception to the hearsay rule, which there's a lot of exceptions to that. So if you're like, Dad told me 12 times that I was going to get that GMC truck, and then turns out that GMC truck had a joint ownership with the daughter, and you now want to go to court and name all the 12 times that he said that to you, you can't, unless there was another person that overheard it that's not going to get the truck. Okay, so conflicting messages, that's a big one. Don't tell people things that are not in your estate plan, and if you do tell them and then you change it, you have to tell them that you changed it. All right, businesses without an operating agreement. Anybody in here own a business? Okay, so you want to make sure, you may already have it. If it's a single member business, okay, good. You're winning already. I've seen so many LLCs come in, and they're just handshake LLCs, especially when they have multiple members. And then there's cattle, and now we've got multiple brands on cattle, and no one knows who owns anything. So if you have a business, as long as you have an operating agreement, that is a really, really good first step. And that operating agreement actually can be part of the estate plan. You can put a succession plan in there. So. And then this was the other big one, cohabitation without a cohabitation agreement. So if you are not married and you live together, you really, really, really ought to consider a cohabitation agreement. It's like an agreement for who owns the house that you live in. Is somebody paying rent? And if they help with the mortgage, do they own any part of that, or are they just paying it like it was rent? If you are both paying for groceries or bills, like who's going to pay for those? Who owns what within the house? If there is a breakup, who gets to stay, who gets to leave? How much notice do you get for those kinds of things? If there's a pet, who owns the pet and gets to take that? I've had an entire court trial over who owns the dog. And it's not a simple answer, actually. It's not just who bought it, because some judges will treat it like a child and give you parenting time with the dog, mostly in Boulder. And then some will treat it like property and say, well, who purchased this dog? And, but then there's questions of, well, who was training it and who brought it? Anyway, there was a whole trial. So cohabitation agreement should work through all of those kinds of things, so that if you're in that situation where all of a sudden you thought you were supposed to get this home, but if the other person was on the title and they passed away, literally things like, it's not like you can go in and say, well, clothing is usually easy, but you can't go, I own this set of dishes. No one labeled it. And so you have to prove what you own and what they owned, and it's really difficult to go back and do that. But a cohabitation agreement does that. All right, those are the main mistakes. So must-knows, which this one we'll just kind of go over basically each of the documents. So estate planning is, again, it's like making a legal decision when you no longer have the ability to do that. And that can be either in life or in death. So a lot of the documents that are the most important are actually the living documents, the powers of attorney, the healthcare directive, that advance directive, those kinds of things. So have you guys seen all of these before? These new to anyone? This is pretty much what isn't included. When people say an estate plan, that's kind of what they mean. And then the trust one at the top is optional. So if you have a trust, you will still have a will. You still have the memorandum of personal property, an advance directive, and all the others. So let's just kind of go through each one here. So trust or will. So trust, again, is kind of like a business. It's going to be represented by paperwork. That paperwork is going to have the rules for how you want to do things. What do you want to have done with your assets? When you put the assets into the trust, that's called funding the trust, which means you change titles. And it no longer says this belongs to Mary Sue. Now it says this belongs to the trust of Mary Sue. That will also be a document where you can name who gets things during life and who gets things during death. There's a lot of different types of trusts. Generally, the categories are revocable or irrevocable. And the biggest difference is if you make it irrevocable, the IRS gives you benefits for that. It's just a tax vehicle. Like what I'm allowed to change it or I'm not allowed to change it. Most trusts are revocable trusts. And they're going to just say things like, during my lifetime, I want the trust to give me income and or principal for my health, education, maintenance, and support. And you kind of get to decide more or less what that means. And then when I pass away, it goes to my children, and they get money from the trust, distributions from the trust for their health, education, maintenance, and support till they reach whatever age you pick. And then at that age, they get a percentage of, they just get an outright payment. That's how most trusts are written. And then wills is similar, but you can't do those specific rules. It's basically you're just going to be giving things away. You can give things away by percentage. You can give things away specifically. That's called a specific devise. You can say, I want this particular item to go to this person, and then everything else, 40% to Sue and 60% to whoever. The other thing that a will does is it's going to name who you would want if you had minor children. So if you have kids and they have minor children, it's going to say who you want as the guardian and conservator for those kids. So that is super important. That's where we talked about if both parents die, everyone's fighting over who's going to be taking care of those kids. This is where they get to say who they want to do that. Guardian is the person that takes care of the daily needs, like where are they going to live, where are they going to go to school, what health care are they going to get, and usually actually cares for them, lives with them. Conservator takes care of their financial needs, so how you handle the money that they're going to receive. The memoranda right there it's a personal property memoranda. This goes along with a will. It's basically, you're going to handwrite it. It's going to be things, heirlooms that you want to give away, you can put in that document. And the reason it's handwritten and separate is so that you can change it from time to time without having to go back to an attorney and pay a bunch of money to change things. And it's where you'll put smaller things. You can't put money in it. You cannot put real estate in it. That's what went wrong in my one case. But you can put heirlooms, jewelry, awards that you've won, things like that you want to pass down.
So then that requires your signature, does it require anybody else's?
It requires your signature only. No witnesses needed, no notary needed. But you do have to sign it. I have had one where I had to administer an estate, and that was unsigned. And as the executor, I was not allowed to follow it unless everybody agreed. So it does have to be signed. The next one is an advance directive. You'll also hear that called a living will. That's a document where we've decided that there are certain things that are so important for your health that you need a separate document to tell doctors what to do. This is the one that will say what you want to do if you have a terminal condition or a persistent vegetative state. So if you've been deemed to be in one of those situations, you can tell doctors how much life support you want and how much artificial hydration and nutrition you want. It can be none, it can be a certain number of days, or it can be indefinite. But you have to have that document. Your agent in a power of attorney usually can't make those decisions for you. That's the next one, though. The healthcare power of attorney is who do you want to make decisions if you're under anesthesia and someone's got to pick between option A and option B. Something went wrong with your procedure. That's where you name who you want making that decision. Most hospitals have those, so you may already have one. Usually if you go in for some sort of a procedure, they'll make you sign one if you don't already have it. But that can sometimes cause conflict, so it's helpful to have the same one that you give to everyone in case you accidentally told one hospital one thing and one doctor another thing, and then they're working on the same issue. Last thing, the financial power of attorney is similar. So that's the same type of thing, but for your bank accounts, who can access your bank accounts and pay. Okay, something really quick because we're almost done, but really importantly. I often hear people say, well, I put my daughter on my bank account, so I'm good. That's sometimes true, but there's 3 different things that you could mean by that. And for whatever reason, tellers at banks are not good at explaining this. You can be on a bank account as a co-owner, you can be on it as a signer, or you could be on it as a pay-on-death beneficiary. They're very different, and Medicaid treats them differently. If you have placed somebody as a co-owner on your bank account, the Medicaid folks will look at that as potentially a gift that you gave away again, and they're going to penalize you for it. So the funds that were in that account are accessible to that co-owner. That co-owner can spend it. And again, I've seen litigation on this. We've seen daughter was placed on account. All of a sudden, trips are happening, and mom came with me on the trip, and that's not always true. And so then when we need to use Medicaid for mom, now Medicaid is saying, well, you spent $45,000 in Cabo, and you spent this, and you spent that, so now you don't get to go into a facility for 3.5 months or a year or however long. Okay, so that's the co-ownership. The other one you can do, though, is just a signer, somebody that can sign on the account. That's not the same. Medicaid doesn't look at it the same way. It's just someone that can help sign checks and things like that. Even that, though, I mean, it's best to do that with a financial power of attorney. It's similar idea. You're naming somebody who is allowed to help with that. The reason why it's better with financial power of attorney is because they take on a responsibility. A co-owner doesn't have that. When you do a financial power of attorney, they're a fiduciary, and now they are responsible to handle your money the way you want it handled. And if they don't, they can get in trouble in court. And that helps with Medicaid too. And then the last one is the pay-on-death beneficiary. So that doesn't give them access to sign checks or look at your account at all, but they would get those funds directly after you passed away, kind of like we were talking about, where you can do that direct gifting, and it comes off the top of your estate.
What did you call that last one?
A pay-on-death beneficiary, or sometimes they'll say POD.
Okay.
Mm-hmm. All right, last two documents. The next one is the disposition of last remains. This is a document where you can explain what you would like to have done for a funeral or cremation, a memorial service, anything like that you would like to do. These are not fully legally binding on your heirs. They are strong suggestions. They have to be followed if it's reasonable at the time. But I've seen somewhere they say, I want everybody to go to Singapore on my dime. And then there wasn't enough of a dime to do that, so they don't always have to follow it. And then the last one is just a HIPAA release, which those are already kind of embedded in the advance directive and the healthcare power of attorney. It's just an extra document so that a doctor doesn't have to flip through your healthcare power of attorney to make sure you included that phrasing, so that whoever you listed as your agent can see your medical records and make a decision in context instead of without knowing, all of the other things that are going on for you. So those are the main documents for estate planning for basically anybody other than someone that only just wants a will to go to their spouse and then their children. So the same thing will happen with or without it. All right, any questions on any of that?
Quick question on POD and TOD.
Uh-huh.
So, payable on death and transferable on death. So if you have like I had an account with my mom, and if I want to keep that account open, it has to be a TOD, right? Or if it's a POD, they have to give me the assets left, right? And then
I think
close it
so.
out.
Yeah, I mean, that terminology I think might be specific bank by bank. It may not be. But if it's payable on death, that usually means that you were not on it at first. You didn't own it. And it's kind of like a life insurance policy. Yeah, they'll just pay it to you, and then that account closes. So yes, if you wanted the account to remain open, you would need to be probably a co-owner. Even then, some banks will say, if one co-owner passes away, we really want you to open a new account.
So like if you had a 10-year CD and it was good rates and you wanted to maintain that, they'd rather pay you out, I think. But you wanted to maintain that, take over ownership, it would have to be a TOD?
I think so. That was something you would ask the bank, though, because that's not, I think that would be bank by bank. But that's, yeah, if you found a good rate on a CD, let everybody know where that was. Yep.
Not as good of a rate as Cap HA.
Yep. All right, any other questions?
Back to the bank stuff, so the Medicaid penalization only happens if it's within 5 years?
That's how far they look back. And what they're looking for is if you gave away a gift without, they call it due consideration. Consideration is a legal word for the exchange, like what you got in exchange for it. So if you gave it away and you didn't get enough back for it, yeah, they're going to look back. They're going to look back for 5 years though.
I have one more quick question. I recently heard another lawyer speaking on this subject, and they said there was a benefit to getting a Wyoming address and doing your trust there, right? And then you could include your Colorado assets. I think tax benefit, right? Are you aware of that, or what?
I'm not licensed in Wyoming, so I can't say that for sure. I mean, I would guess they were accurate if that's the case. That they're probably talking about somebody who would be subject to estate taxes, so they would be over that 13.99 million or lifetime gift, I'm guessing.
Why go establish that?
Yeah, I'm not sure, because especially if you forgot to fund it all the way, now you'd actually have to do 2 probates. So if you own if you own real estate in 2 places, or you pass away in one and own real estate in another, usually you have to do probate where you passed away, and then they do an ancillary, which is kind of a mini probate in the other state. It's not super tricky, but it's 2 full processes. Oh, and one last question somebody had asked me was about the cost of probate. Just so you know, your heirs will just pay the actual costs, whatever that is. So the court filing fee is like $250, and then you have to pay $12-ish for each time you file in court after that. And there's about 3 or so other things you would file. And then if they get an attorney, they'll just pay those attorneys' fees. Most attorney fees are anywhere between like $250 to, I wish not, but some people are like $450 an hour. If you go to Denver, you're going to be more than that. But we've done probates for $2,500 if no one's complaining about anything. So that there's not like a percentage that goes. It's just the actual costs of that process. And the same thing is true of the trust administration. Usually that person wants an attorney to help with that. The trust is gonna pay for those costs too. So, all right, I think that's it. Probate, it can be closed. It can be opened and closed in the 4 months that you give the creditors, and we've done some like that. It's safest to wait 1 year. There's a few types of creditors that are allowed to place a claim after the 4 months, mostly government taxes. But usually after a year, everyone is done. So a year, but 4 months is possible. We do those often, and we just tell people, just know that if taxes come out, that you'll have to give those funds back for the taxes. So, unless there's a fight. Sometimes if there's a fight, I've seen one for, I think, close to 2 years. So, okay, any others? Yeah.
So what happens with like digital assets? I'm talking about Google accounts and things like that, because can be a sticky issue.
Yeah, so most wills now will have a section in there for digital assets where you allow authority to access those. And then if you do a personal inventory every year, that's where you can say which accounts you have and what your username is. Some of them also have their own setup. So like if you have a Facebook account, you actually can go in and already name somebody as your successor on that one. Good question, yeah. Any others? Okay, well, if anybody needs help with anything, we have a pamphlet there for you. I'm always happy to answer questions too. Like I said, we're not hurting for work. We really just want fewer fights if possible. So if you have questions, feel free to reach out.
All right, thank you, Bryn. That was very educational. Hopefully everybody learned something. I do every time that I talk with her. So thank you for coming. There's some food in the back if anybody's still hungry. Cookies on the tables. And thanks so much for coming.